They're all from the same date. They're all right. I see. So case number 3A0257205, State versus Muhammad Idris. Charges vehicle operator refused to comply with the police officer. There are 2 infraction charges as well. 3A0096934 is violation of a special trip permit, and 3A0096933 failure to obey traffic control device and failure to renew his expired registration on a vehicle. Mr. Kale, any contact from Mr. Idris?
Either Mr. Idris or a representative of Mr. Idris is present on Zoom, Your Honor. And I believe he may tend to proceed pro se, or at least without the assistance of public defense. So I would ask the court to inquire with him about that.
I will. So on the screen, listed as Muhammad, authorized representative for Muhammad Idris. Is that right?
First of all, I object to public defender saying that I'm pro se, which I am not. I'm the authorized representative on behalf of the estate. And I would like to request for continuance due to I made a request for discovery, and there was no email provided to me. And I was informed that only a phone number is available. And I called that phone number, and there was no answer. And I did not get any voicemail. And out of the 3 cases, I only received notice for 2. 1 is missing. I don't have the paperwork for that. Due for that reason, I would like to get a continuous.
All right, so let's start with this. Are you Muhammad Idris? Let's get the name straight to begin with.
That's the estate on the trust. I'm the authorized representative on behalf of the estate that the court is trying to administrate.
Well, the state's not charging the estate. The state is charging Muhammad Idris. So that's who we need to address. Is that you, is my question.
I object. If I have a question for, that's a question for the prosecutor, correct?
Well, you're here asking for a continuance because you want something else. I have to know who it is that is requesting the continuance and how you speak on behalf of Muhammad Idris.
I'm the authorized representative of the estate. Like my family name is Idris, given name Muhammad Ismail, for the estate, which is Muhammad Ismail Idris, estate on a trust.
Right from the jump, this case sets off every alarm bell you'd expect in a courtroom that's about to spiral into procedural chaos. We're dealing with multiple traffic-related charges, a refusal to comply with law enforcement, expired registration issues, and infractions tied to commercial vehicle operation, all seemingly straightforward on paper. But what makes this hearing fascinating isn't the charges themselves. It's the way the defendant shows up. Instead of simply identifying himself, Muhammad Idris enters the courtroom claiming to be an authorized representative of an estate and trust, insisting the person charged is not actually him. This is a familiar tactic that courts across the country see repeatedly, often associated with sovereign citizen-style arguments. The judge, meanwhile, is trying to do something very basic: establish who is actually in front of the court and whether they have standing to speak. And as you're about to see, that simple question becomes the battleground for everything that follows: continuance requests, objections, identity disputes, and escalating frustration. Stick around, because this hearing becomes a masterclass in how courts handle procedural obstruction without losing control of the room.
All right. As I say, the estate is not being charged with a criminal offense. Muhammad Ismail Idris is being charged with criminal offenses. Now, you indicate that you only got 2 of the 3 notices. Which charges did you get notice of? Did you get notice for the failure to obey traffic signal?
I object to your saying this has nothing to do with the estate. It has everything to do with the estate and the trust that's being charged.
Well, not to be argumentative, Mr. Idris, but the estate wasn't driving the vehicle. I suspect the city or the state will try to prove that Mohammed Idris was driving the vehicle. That's their job in this case.
I object. That's a hearsay. The court is assuming and presuming that's the case, which is not. So if you can continue with the continuous, I'll appreciate it.
Well, I'm going to ask the city, or the state rather, to establish probable cause at this time on the charge ending in, or the case number ending in 7205, which is the vehicle operator refusing to comply with the officer. You've already been sworn, Ms. Mann, so we'll go ahead.
The charge of refusal to give information on May 11th, 2023, Officer Kelsler responded to a request for assistance from Officer Turner, who had performed a traffic stop on a commercial motor vehicle that was traveling in a left lane prohibited for CMVs southbound I-5 at milepost 96. The driver was later ID'd by his DOL photo on file as Mohammed Ismail Idris, and
I object.
Both officers within the ID, despite multiple...
Mr. Idris, hold on, Ms. Mann. Mr. Idris, please, let her finish.
Okay.
Let her finish. Go ahead, Ms. Mann.
Refused to provide both officers with an ID despite multiple requests by both officers. He was cited for operating a vehicle and refusing to comply with the police officer and released.
He was also charged with the infractions at that time?
Yes, Your Honor. And I have a probable cause for the special fuel trip permits violation as well, if you'd like.
Yes, why don't you give us that too?
On May 16th, 2023, Officer Turner observed a tractor trailer traveling south on I-5 near milepost 98, speeding and traveling in a restricted left lane. The officer made contact with the driver, who refused to identify himself, but was identified through his DOL photo on file as Mohammed Ismail Idris. While looking up his inspection history, it was revealed that the registration on the power unit had expired several months earlier and was revoked by the Washington State Department of Licensing. He was cited and released.
Is it my turn to speak?
All right, Mr. Idris, it's now your turn. Go ahead.
I object. I requested for continuous, and I was not informed if it was denied or granted. And I do not consent to being for the court to move forward. If you guys decide to move forward, I prefer physically present instead of a Zoom call, if you guys decide to continue.
This is the first major turning point. Instead of answering a direct question, "Are you Mohammed Idris?" the defendant pivots immediately into legal wordplay. He rejects the idea that he's representing himself and insists he's merely an authorized representative for an estate tied to his name. From a legal standpoint, this is a dead end. Criminal charges attached to people, not estates, trusts, or fictional legal constructs. The judge recognizes this instantly and calmly redirects the conversation back to reality. What's important here is how patient the court remains. The judge isn't dismissing the defendant's concerns outright. He's simply trying to establish jurisdiction and identity so the case can move forward. But the refusal to answer a basic identity question is a common tactic used to delay proceedings and muddy the record. Courts see this often, and as you'll notice, the judge doesn't get baited into an argument. He keeps bringing it back to who is charged and who is speaking.
And what's the basis of your objection again? Why you want a continuance?
The reason I need the continuance is out of the 3 cases, the case number, I only got 2 notices, not the third one. One is missing. And also I requested for discovery to the clerk of the court. And they said, I have to get hold of the prosecutor office. And I got hold of the prosecutor office. There's no email for me to request for the discovery. The only way is a phone number. When I called the phone number, nobody answered. So how can you guys continue without, I don't even have any discovery. So I don't know what's up against me. I don't have the details of the discovery.
Well, you've heard what's against you. Ms. Mann just repeated what she believes the state will be able to prove in this case.
There's not a proper notice.
Mr. Idris, hold on. It may be that the two infraction numbers appeared on the same document, case ending in 933 and case ending in 934, since they're both infractions. And then the second one would end in 205, which is a criminal charge. So that's a possibility. But based on your request to have this set over, we will set out the arraignment and you may appear in person. There's nothing stopping you from appearing in person.
Physically present.
Yes, in person. All right, although I believe there is probable cause been established, I'm not going to find that today to give Mr. Idris the opportunity to look at all these documents. And Ms. Mann, is there some better way for him to request the discovery in this case that he's talking about?
Not that I know of, Your Honor. I could check with my supervisor.
All right, go ahead. In the meantime, while we're looking for that information, Mr. Idris, I want to confirm a mailing address for you or for your estate. Let me check for a moment.
I object. I'm not a mister.
Pardon me?
I say I object. I want to make a correction. You called me mister. I'm not a mister. Mister is a title.
Is your address still on in Seattle? Mail.
Here's where the legal reality really starts to collide with the defendant's narrative. The judge makes a critical clarification. The estate was not driving the vehicle, a human being was. That distinction matters. Traffic violations, refusals to comply with officers, and licensing offenses are personal acts, not abstract administrative events tied to a trust. When the defendant objects and calls this hearsay, it highlights a misunderstanding of what hearsay actually is. The court isn't offering evidence yet, it's explaining the nature of the charge. And that's a key difference. At this stage, the court only needs probable cause, not proof beyond a reasonable doubt. The judge's tone remains controlled but firm, signaling that these arguments aren't going to derail the process. This moment sets the stage for the prosecution to formally outline what they believe happened, and once that starts, the procedural smoke screen begins to collapse.
Is that a P.O. box in Tukwila?
That ends with
I'm seeing a P.O. box stated in Tukwila, Washington.
There's a dash at the end, 9998. There's 999 and 8. Those 4 digits is very important to put it on there.
So 8-888-9.
No.
I messed those last 4 up. What? What's next?
Like I said, I don't have an address. I have a private location where I can receive for mailing purposes only. And the only thing I will indicate is the last 4 digit after the end of the location, which ends 9998.
Is that a street address or a mailbox? Post office box.
That's my mailing location where I can receive notices only.
We can't address notice to you at 9998. I need more than that. what happens, Mr. Idris, is if you don't respond to this, there's going to be a warrant issued for your arrest. We have to give you notice first. That's what we're trying to get established here.
I object. Notices can be sent to me through my private email as
Are you
well.
going to give us that private email?
The court has it on file.
This is where things shift from abstract argument to concrete allegations. The prosecutor lays out the facts as they understand them. A traffic stop involving a commercial vehicle, repeated refusals to provide identification, and eventual identification through official records. Notice how the judge steps in immediately when interruptions occur. That's not accidental. Courts protect the integrity of testimony, especially during probable cause statements. The defendant's objections don't stop the narrative because, procedurally, they don't need to. At this point, the state is only required to show that there's a reasonable basis to believe the offenses occurred. And when the prosecution adds the second incident, speeding, restricted lane violations, expired and revoked registration, a pattern starts to emerge. This isn't a one-off misunderstanding. It's repeated conduct. And patterns matter in court, especially when deciding whether to move a case forward.
Your Honor, good afternoon. This is DPA Tom Farrow. Before we proceed beyond this case, I'd like to address the court.
All right. I'm trying to get a mailing address here. Mr. Idris, we have two addresses from the Department of Licensing. One is on Avenue in Seattle, and the other is a P.O. box in Tukwila. If you're not willing to provide us with your email address, we're going to just send notice to those two addresses.
I object. Again, I'm going to make a correction. I'm not a Mr., which is a title. If you can call me with my proper name, which is a family name and a given name, I'll appreciate that.
Yes, Mohammed Idris. We're going to send notice to those two addresses that we have.
You meant to say
unless you give us something different.
You meant to say my family name, which is Idris.
All right, we're going to use that. That's what he sent to us, requesting information about court, correct?
Now we reach the defendant's strongest procedural argument, and it's the one the judge actually takes seriously. Access to discovery and proper notice are fundamental rights. If someone genuinely hasn't received paperwork or can't reasonably request discovery, the court has to pause. What's interesting here is that the judge doesn't immediately rule against him. Instead, he listens, clarifies, and even acknowledges that the infraction cases might have been bundled together administratively. This is the difference between obstruction and legitimate concern. The judge separates the two. He doesn't reward the identity games, but he does ensure the defendant gets time to review the evidence. That balance is crucial. Courts don't punish people for asserting rights, but they won't allow those rights to be used as shields to avoid accountability either.
When you requested
just before we go on.
All right, Mr. Farrow, let's hear from you.
Thank you, Your Honor. I was listening on the YouTube. I wanted to address the court just to highlight the fact that Mr. Idris was given the constitutionally required notice at the scene on at least two of these cause numbers. There are citations in the record. Those were handed to him, and he was advised of the upcoming court date. That's kind of my first point. So I think if the court wants to continue, I don't know when he was first scheduled for arraignment, but it looks like this has been going on for a little bit. If the court wants to continue on those two matters, I'm happy to. I mean, it says here, it's checked the box for the ticket was served on the violator. I'm happy. I guess I could send something to one of these email addresses, but I would also urge the court to note that if you look on Jabs, we've tried sending mail to Mr. Idris. It is not, or it's been returned. Finally, Your Honor, and I'm not trying to be silly about this, but I've sort of heard these arguments before in court, and I think I know where we're going with this. The state's not satisfied legally that the defendant in this case has appeared today. I think he's claiming to be some sort of representative for some sort of estate or trust or other nonsense. But based on Mr. Idris's failure to appear today, the state would request the court to issue a warrant.
This moment shows judicial restraint in action. The judge explicitly states that probable cause appears to exist, which is significant, yet chooses not to formally rule on it today. Because fairness matters more than speed, the court wants to eliminate any claim that the defendant wasn't informed or prepared. Allowing an in-person appearance and delaying the arraignment protects the record and prevents future appeals based on procedural issues. This is smart judging. It's not about winning an argument in the moment. It's about ensuring the case stands up later. The judge even asks the prosecutor to explore better discovery options, signaling transparency and cooperation. That's how courts maintain legitimacy, especially when defendants are openly hostile to the process.
I object. Everything he said is a hearsay, assumption, presumption, and tacit agreement. It has nothing to do with the facts. He's not telling the truth, the whole truth, and nothing but the truth. And he was supposed to take a stand and write an affidavit. He's not doing any of that. He's just waiting for my silence, acquiescence. So I object to everything that he said.
All right, I understand that. Mohammed Idris, he makes a good point. If you're going to argue that you are a representative for Mr. Idris, Mr. Idris hasn't made a full appearance in court yet today, and therefore that would lead to the potential issuance of a bench warrant for your arrest for not showing up. So can we resolve that question at least, that Mohammed Idris has appeared for arraignment today?
I object. Again, it's what you're saying. Everybody in the court is saying is assumptions, presumptions, tacit agreement is a hearsay. You cannot use a hearsay or assumption and presumption in court. It's wrong information, and I object to all of that. And I am not a representative. Like I said I am authorized representative or an agent or an executor of the estate on behalf of the estate and trust.
And as I've indicated, the estate was not driving this commercial vehicle at the time these citations were issued. So I'm not going to accept that. I'm not going to carry this on further, Mr. Idris.
Do you have a power of attorney for this matter to continue?